Why on earth would you appeal a decision that you won? Like in Bart's v. Anthropic. Remember that? This is a huge win for AI, exceedingly transformative, and was a fair use, quintessentially transformative. Spectacularly so. The most transformative many of us will see in our lifetimes. And this is from a guy who's seen a lot. This is no longer an AI case, it's just a piracy case. The AI part is over and done. So why appeal that? Well, because if you remember, they didn't win all of it, did they? They won decisively on the idea that training in AI was absolutely transformative fair use. They lost on the question of, if you remember the hysterics the Bart's plaintiffs went through about, it was piracy! They were stealing the fires from Prometheus! This was like Napster and all that. That was the part they didn't prevail on. And so I was asking the question, is it still an AI case, or is it now just a piracy case? Well, Anthropic is now saying, hey, it's still an AI case, and we should have won that point. And so what they're asking for is permission to make an interlocutory appeal. This is different from a regular appeal where you just save up all of your appealable issues, you preserve them from the record, and then after everything's all over with, you appeal up to, in this case, the Ninth Circuit. An interlocutory appeal is when you just go ahead and appeal, hey, there's this one particular issue, and it means that whatever this issue is, it'll affect everything from here on out. And that being the case, let's just go ahead and do the appeal and figure it out, and that'll help us know where to go from here. And in the alternative, if they don't prevail on that, they're going to ask him to reconsider his opinion. So we'll get into this. This is a 26-pager. We are not doing all 26 pages. In fact, we're skipping up to page 13. That's 13 of the PDF file for those of you following along. Remember, go with the blue page numbers at the top, not the page numbers at the bottom, which in this case says it's page 8. It's really page 13 of the PDF file. And so they're pointing out that he kind of asked the wrong question. The question here is whether to analyze the defendant's ultimate purpose, in other words, to do this transformative thing of training an LLM, or instead seek to assess each subsidiary step. And that's a legal part of the fair use inquiry. It's about the law, not about the facts. This has nothing to do with the fact part that will be figured out in discovery, because we're not that far yet. Because remember, in Kadrey v. Meta, they had finished both fact and expert discovery. They're not that far along yet. They've still got discovery to do. But they're saying regardless of what facts that might end up being shown in discovery, this is a legal matter, so go ahead and figure that out. So they say here the court analyzed Anthropic's conduct as multiple subsidiary steps rather than focusing on Anthropic's ultimate purpose of using the works to develop its LLMs. So it's like I said, you grab the content, the copyrighted stuff you're using, books or whatever. Then you do something, do something, do something, do something. And then the final output is your product that you deliver to the public. And the question is that final product infringing? And so what Judge Alsup found is that since the training step was transformative, everything after that was transformative, and therefore Claude AI does not infringe on the original author's works. But what they're saying is that you look at the ultimate purpose. If that ultimate purpose is transformative, as Judge Alsup found that it was, you also take it all the way back and say the initial acquisition was fair. And as we talked about Judge Alsup, he seemed to be kind of open to that idea because everything he was saying was about the fact that they kept the works after they trained the AI, and it looked like they were going to do other stuff with them. And so they said the court therefore parsed what it viewed as distinct acts: Anthropic's initial copying, its supposed storage in a central library, its training of LLMs, and its supposed retention of books after their use for training. And within that piecemeal analytical framework, the court placed greater weight on whether Anthropic immediately transformed the downloaded books and immediately discarded them. And so the court concluded that books downloaded from pirated sources and stored in a central library were not fair use. If the court had instead adopted Anthropic's argument that it should look only at the ultimate use, namely developing the LLMs, the outcome would likely have been different. Anthropic's framing accords with Section 107, which is about the purpose and character of the use, without directing courts to deconstruct the defendant's use into constituent steps. Under that framing, Anthropic's actions were all interconnected, necessary elements in pursuit of the single purpose of LLM development, which this court recognized as among the most transformative uses many of us will see in our lifetimes. So it doesn't matter whether Anthropic immediately used the books for training, whether it immediately discarded them thereafter, or whether every book became part of the LLM training corpus. Indeed, neither the Ninth Circuit nor Supreme Court has considered promptness of a defendant's use and deletion of copyrighted work in this manner. So it doesn't matter how long it took you to use them. It doesn't matter how long you kept them afterwards. None of that matters as long as the ultimate purpose is fair. Next page, page 15. The court's emphasis on subsidiary steps rather than ultimate use also led it to focus on Anthropic's supposed creation of a central library of text, which it compared to any university or corporate library, and they look at Texaco again. But they say Anthropic acquired, stored, and organized books not so they could be used for their original purpose of being read, but rather so that they could be used for the transformative purpose of developing LLMs. Importantly, Anthropic is an AI company, not a library or even a more general technology company that might put the works to some other use. And nothing in the record supports the conclusion that any Anthropic employee read a single one of the books at issue. Anthropic has no research objective that requires consuming the books as ordinary reading material. It only has the transformative objective of developing LLMs. So they're saying, hey, we're not like Meta, which also does all this social media stuff. We're not like Google, which does every damn thing there is in tech. We just do AI. We are just an AI company. LLMs is our product. That's what we do, and that's only what we do. So Judge Alsup, when you're looking at them and say, hey, you've made those for other uses, are those other uses fair? Well, you said yourself, AI training is transformative. That's all we do is AI training. So there's nothing we could possibly do with those books that isn't transformative. And they say if the court had appropriately focused on Anthropic's ultimate purpose in using the books, it would not have separately analyzed Anthropic's supposed library use at all. Jurists can reasonably disagree, and indeed have disagreed, over whether fair use in the context of LLM training should be analyzed by reference to ultimate purpose or broken up into subsidiary steps. In Kadrey, we went over that one, Judge Chhabria mentioned that all of Meta's copying must be considered in light of its ultimate, highly transformative purpose, training the LLM. Because all relative copies had the ultimate purpose of LLM training, Judge Chhabria found them all to be protected by fair use, even if only some of them were used for LLM training. This reasoning cannot be reconciled with this court's focus on subsidiary steps rather than ultimate use. And they do say, elsewhere in this filing, that Judge Chhabria's decision isn't restrictive on this court. They don't have to follow it. But these are both going to go up to the Ninth Circuit. And if you've got these two conflicting ideas that are going to go up to the Ninth Circuit, might as well go up and ask them now. Even if Meta did download some copies that weren't ultimately used for training, fair use doesn't require that the secondary user make the lowest number of copies possible. And he never considered whether Meta had retained copyrighted books after using them for training. Judge Chhabria's reasoning cannot be squared with this court's concern that not every copy Anthropic made was even necessary nor used for training LLMs, which undergirded its conception of a separate central library use. And here we go! Contrary to the court's suggestion, Warhol, oh my God, Warhol. Such a terrible decision. The Supreme Court observed that the same copying may be fair when used for one purpose, but not another. But the original photograph in Warhol was copied to multiple distinct ends, creating an illustration, creating 15 further works, to licensing one of those works to a magazine. Here, the asserted uses, downloading the books, storing the data, training the LLMs, and retaining the data for future training, are all interconnected steps. As noted, Anthropic is an AI company that develops and researches LLM. It has no other mission or product to which plaintiffs' books are plausibly relevant. AI stuff is all we do. If AI training is transformative, then it doesn't matter what other purpose might be for us retaining the books. Whatever else we're going to do with the books, it's going to be just as transformative. Because we are an AI company, and that's all we do. That's what they're saying. And also, they say their position is supported by Ninth Circuit precedent. The Ninth Circuit did not ask whether the images were deployed immediately or immediately deleted, nor did it suggest that the defendant's uses were unfair simply because they had downloaded the plaintiff's images. The court found fair use while deeming it irrelevant that the defendant may have made more intermediate copies than necessary and repeatedly copied material. And this is a couple different cases they're talking about. One is Perfect 10 and the other is Kelly v. Ariba. And they say, as this court recognized, LLM development involves multiple steps. A copyrighted work therefore cannot be immediately used to train an LLM, in part because it takes time to amass and assess the amount of diverse data required to train a model. LLM developers may store raw data for further processing as advanced techniques develop, as well as to run experiments comparing old and new methods to determine which results in a more capable LLM. In addition, defendants who immediately deleted training data would run the risk of spoliation accusations by potential plaintiffs. In other words, all copyright challenges to generative AI tools, plaintiffs could seek to parse the process of LLM training into constituent steps and argue a lack of immediate use. The acceptance or rejection of such arguments could well shape the outcome in this entire line of industry-defining cases. So they're also saying it's a bit like Morton's Fork. You keep them around, oh, that's a violation. You delete them, oh, that's spoliation. But we've covered more than one case of these plaintiffs in all these AI cases working with Catch-22s. If the Ninth Circuit were to adopt Anthropic's view that the ultimate purpose of developing the LLM is what matters, then it would be legally irrelevant whether Anthropic took the supposed initial step of assembling a central library of data or the later step of retaining copies that may later be needed for further training. In that circumstance, summary judgment should be granted for Anthropic in full, averting the need for a trial. They're saying if they prevail on this, then it's all over and done with. And you don't even need to go through fact discovery or expert discovery or anything like that. It's done. Done and dusted. Because they have nothing. Moreover, even if the Ninth Circuit were to adopt a position other than Anthropic's, it would provide helpful guidance on the proper fair use standard and minimize the chance that any trial will have to be redone, thus materially advancing the ultimate termination of the litigation. Next page, the Ninth Circuit found fair use even when the defendant copied images from websites that had themselves distributed those images without authorization. Thus, the court's analysis raises the legal question of what effect making an initial copy from an unauthorized source, here the so-called pirate libraries, has on the fair use analysis. Indeed, if the court ultimately adopts that rule, then Anthropic's fair use defense could fail, even if Anthropic disproves the notion of a general purpose library, as it believes it will upon more fulsome development of an evidentiary record. So another damned if you do, damned if you don't. And also notice that they're just denying that they created a library. There is no library. We retain the works because we might use them for future LLM training. There might be future LLMs that we don't know we're going to do yet, and we're going to hold them around for that. But that's the only thing it's going to be because that's the only thing we do. We're an AI company and nothing else. Reasonable jurists may disagree, and indeed have disagreed, about the significance of initial acquisitions of copyrighted work from third-party sources that distributed the work without permission. 2 days after this court's ruling, Judge Chhabria granted summary judgment to Meta on the plaintiff's infringement claim, despite the fact that Meta downloaded the plaintiff's books from shadow libraries and did not start with an authorized copy of each book. Judge Chhabria explained that to say that Meta's downloading was piracy and thus cannot be fair use begs the question, remember we covered this, because the whole point of fair use analysis is to determine whether a given act of copying was lawful. So you don't get to start with that. You don't get to say, oh, they pirated it, they got it illegally, that means, well, no, if it's for a fair use purpose, that's the whole point of the fair use analysis, is to determine if that copying was fair use. Judge Chhabria's reasoning conflicts with this court's suggestion that a defendant may not be able to prove fair use after downloading source copies from pirate sites. The entire premise of these cases is that technology companies train their LLMs on copyrighted content absent the rights holder's authorization. The fair use analysis should focus on the copies made by Anthropic, not copies made by third parties over whom Anthropic had no control. Whether the rights holders authorized an unrelated third party to make a predicate pirate copy of the works should not taint the defendant's subsequent transformative use. Nor is it enough to say that the defendant's copying was unauthorized, because that is an inherent feature of a fair use inquiry. If a contrary position were widely adopted, then LLM training by any company that downloaded works from third-party websites like LibGen or Books3 could constitute copyright infringement, even though, as this court correctly recognized, LLM training is exceedingly transformative. If Anthropic is correct that initial unauthorized downloading of books from third-party websites should not preclude its fair use defense, as Judge Chhabria held, and in fact should play little if any role in the analysis, then judgment will likely be warranted for Anthropic given its highly transformative use of those works to train its LLMs. That result would avert a trial that may be unnecessary or that will have to be redone under the current legal standard. So yeah, we could wait for the end of this and then go up to the Ninth Circuit, and if they kick it down and they say, hey, you have to do the trial all over again because you screwed this up, what then? Might as well get that answer now. The court and the parties should obtain Ninth Circuit guidance before a trial moves forward. And if you don't want to do that, Judge Alsup, at least let us seek reconsideration of your order. Alternatively, the court should grant Anthropic leave to move for reconsideration of the order. The order failed to consider the material fact that the record does not support, nor did plaintiffs argue, that Anthropic downloaded books to create a general-purpose library separate from LLM development. No one even alleged that. The record does not support the court's conclusion that Anthropic downloaded and retained books to create a general-purpose library of works for various uses which the company might have of them. As plaintiffs have acknowledged, the record only allows one inference, that Anthropic downloaded and retained books to develop LLMs. Because again, that's all they do. They're a single-purpose company. Alright, we're going to skip over to page 24. We are almost done. The court also quoted a statement that Anthropic planned to store everything forever because there was no compelling reason to delete a book. Yeah, there isn't. That's the thing about data retention these days. Drive space is cheap, might as well keep it around. But that statement directly followed a statement that these books' data would be used across all models, that is, all LLMs, and supports the proposition that the future storage was only for the purpose of LLM training. We gonna do new LLMs in the future, Judge. We need to keep these around for that. The court did not have the benefit of a briefing on a general-purpose library theory. Plaintiffs never asserted such a theory. To the contrary, they consistently referred to the relevant use as using books to train LLMs. So Judge Alsup, we got no idea where you got this general library thing from. It's all about training LLMs, which you said was highly transformative, spectacularly so. The most transformative any of us are likely to see in our lifetimes and all that. Because plaintiffs never raised a general-purpose library theory, Anthropic never had a chance to rebut that idea. You never heard from us on that, Judge. This court should grant Anthropic leave to move for reconsideration so that it can now have that opportunity. So based on the foregoing, Anthropic respectfully requests that the court certify its order for interlocutory appeal. Alternatively, Anthropic respectfully requests that the court grant leave for Anthropic to move for reconsideration of the court's order. So this ain't done yet. No, this is not just a pirate case still. There's still a lot of stuff about LLMs here. There's still a lot of stuff about AI training to do because we got these open questions. So we're either going to hear from the Fifth Circuit or we're going to hear again from Judge Alsup. And of course, I'll let you know what that is because again, I'm the only YouTuber covering it. And if you like that and you want to reward me for it, then of course, comments for the comment god, shares for the share throne. Please hit like, subscribe, and the bell. And of course, donate.bogosity.tv. Keep me doing what I do. One-time payments or regular support. Patreon, subscribe, star, Discord. Thank you so very much for watching. Until next time, stay strong and be free.